Good evening to all. Welcome to our IPR Online Faculty Development Program on the session Need for Protection of Traditional Knowledge and Related Patent Issue. It's my distinct honor to welcome our esteemed speaker today, Dr. Pankaj Kumar. Dr. Pankaj Kumar is a distinguished professional in the field of IPR. He currently serves as the DPIT IPR Chair Professor at the National Law University and Judicial Academy in SF. His journey in the field of IPR began in the year 2006 when he joined IP Management Division of CSCR in New Delhi. Since then, he has dedicated himself to providing exceptional service in intellectual property. Over the years, he has successfully filed more than 600 applications for various IPR, including patent, design, trademark, and copyright, showcasing his expertise and dedication to the field. He holds a PhD in biotechnology with a specialization in patent. In addition to his science and law degrees, he has a master's degree in biotechnology, law, and information science. His multidisciplinary educational background measures scientific knowledge with legal proficiency, making him a unique authority in the field. Dr. Pankaj Kumar's expertise and contribution extend beyond his academic and professional roles. He has actively participated in numerous IPR programs as a resource person, sharing his knowledge and insight with aspiring professionals, entrepreneurs, and industry experts. His involvement in this program reflects his commitment to raising awareness about intellectual property rights and fostering an environment of innovation and protection. We are privileged to have Dr. Pankaj Kumar with us today to lead the session on the protection of traditional knowledge. His depth of knowledge, experience, and dedication to the advancement of IPR makes him a valuable resource for us all. And I also welcome all professional scholars and other participants present here for enlarging their knowledge. Once again, I welcome each and everyone present in this platform.
Thank you, Judy ji. And dear participants, I would like to take a moment to express my gratitude for the opportunity to collaborate with Dr. Kalpesh ji this year. It has been a privilege to witness the seamless progress of this faculty development program under his capable leadership. Unfortunately, due to an unforeseen medical emergency in my family, I have had to arrange for an alternative experts to cover my scheduled session earlier on patent. I apologize for any inconvenience this may cause. If time permits today, I encourage you all to take this opportunity to ask any questions you may have about patents or other aspects of IPR. I am here and available to address your queries and provide any necessary clarification. So, aspects of traditional knowledge. This is a very basic information on this first slides that everyone well aware that traditional knowledge are oral and rural in nature, generally generated within communities. Mostly we find systematic documentation absent here. These are generally location and culture specific, just like geographical indication, and difficult to be registered under patent system as being considered in public domain. So there is a problem of novelty. And there are huge biopiracy because it is relatively easier to appropriate such bioresource and the associated knowledge by any person interested without consent of the stakeholder and no any sharing in the benefit with the stakeholder. These are some of the example of bioresource and the associated traditional knowledge like corals, oyster, cuttlefish, bathini fish. Hopefully, many participants must aware that there is a Hyderabad fish remedy for asthma. So this is a traditional knowledge. And see, there are different forms of such bioresource which are utilized. And the particular applications of such bioresource and the associated traditional knowledge. And by this presentation on traditional knowledge, the intent is to safeguard the interest of a stakeholder only and not to promote non-vegetarian resources for consumption. Similarly, there are some example of tribes in India and their associated traditional knowledge. Like turtle, there are different types of turtle, snails, and there are particular tribes in India who applied such bioresources for different kind of applications. We already discussed earlier in some other sessions of FDP different types of IPR. So the concern IPR here for this presentation is patent relates to traditional knowledge. We all know bioprospecting. See the bioresource, the cost of bioresources and after value addition, see the cost of the product. And that's why bioresource and the associated knowledge is in demand. The industry people, the commercial entities, commercializing such resources and knowledge, that is okay. But the problem is they hardly prefer to share the benefit with the stakeholder. This is the problem. Hopefully you all aware about such type of products based on bioresources and the associated traditional knowledge. Dr. Ortho, Madhumani, capsules, diabetes syrup, pet safa. So, can you guess the world best pharmacy according to Ayurveda? Okay, I will again ask this question after some slides. So, world Kusmanda. This is noted neuroprotective properties. It is also known as ace gourd or winter melon. And there are multiple applications of this bioresource that like digestive aids, cooling agent, weight management, respiratory health, blood purification, diuretic properties, boosting immunity, mental health. There are well-known other bioresources like Triphala, Haritiki, Amlaki, Vivitaki, and there are wide applications of such bioresources. Similarly, millets that are rich in several beneficial nutrients like phosphorus, magnesium, copper, manganese, and they help in digestive health, weight management, diabetes management, heart health, bone health, immune system boost, skin health, energy boost, detoxification. So from more than 5,000 years, Ayurveda is the most ancient and oldest surviving continuous practice medical system in the world, mother of various regional traditional medical systems, rooting itself from remote antiquity and history. It has endured and grown through the transmutation and test of time through its scientific background. So there is hardly much difference in traditional medicine and traditional Ayurvedic medicine. In traditional Ayurvedic medicine, we generally understand that this is error-free treatment and for those symptoms without any side effect. So it includes plants, animal and minerals. For medicines, spiritual therapy, manual techniques and exercise. So in many countries, government is promoting such Ayurveda, traditional knowledge, bioresources. Like in China, see the figures here. In 2003, there are 200 hospitals based on such traditional knowledge, and in year 2015, the numbers are 4,000. In India, there is a All India Institute of Ayurveda promoted by PM Modi, and there are various other initiatives taken. So there is a problem of such bioprospecting, that is over harvesting, and sometimes due to over harvesting, some of such bioresources going to extinct. See, the demand of this particular biodiversity, this is a Himalayan Viagra, and this is actually a fungus known as Kirajari. In China and in international market, the cost of this Kirajari is 20 lakh per kg. And due to huge commercialization, many commercial entities try to monopolize over such products, and they try to get patents over such inventions based on bioresource and the associated traditional knowledge. So this is a danger. If such kind of things patented and monopolized by few entities without sharing the profit to the stakeholder, so there is a misappropriation, and that's why this is called biopiracy. See some further example. This is a case of vitiligo, where melon is used traditionally, and in present case, European Patent Office have cancelled this patent application after having evidence from TKDL, that is a Traditional Knowledge Digital Library, that this information is already recorded in India, and so there is a lack of novelty. So this is not new, and novelty is the first criteria for the patent. In another case, Lotus, one application has been filed for the invention based on Lotus for heart disease, and this information is already covered in TKDL. So this is easier to oppose such type of applications based on such records and evidence, and such applications also decline. In another case, ginger, claimed for burning the fat. So along with the ginger, they use onion, turmeric, cumin. But again, this information is covered under TKDL. So based on such TKDL records, such biopiracy controlled. Further, in case of Brahmi Ashwagandha, so TKDL is one of the initiative of Council of Scientific and Industrial Research, and such applications filed in many developed countries like US, UK, Europe, Japan. This application filed in year 2006 by Jane Marini company, but with the help of TKDL records, such application also rejected. Further, Pudina, Kalamega, and inventions filed for patent on bird flu drug using these bioresources. Fortunately, this information is also covered under TKDL, and this company Levozone, a major Chinese pharmaceutical company, filed this application in Europe, and the application number is EP1849473. So with the help of TKDL, India government succeed to reject this application in Europe. In another case, see, India win patent war on hair loss formula, where UK-based company Pangea Laboratories Limited has filed the patent application in year 2011, and TKDL unit objected it along with the evidence, and based on India evidence, the patent applications was finally deemed to be withdrawn. So the company is Colgate Palmolive tried to patent a mouthwash formula containing herbs, jaifal. So there are so many cases, and see, we all know this bell, get Kumari, Google, Haldi, and the indigenous use. Most of we people well aware about the use of such a plant and such plant product. During the study on patent on such kind of things, it is noted that the similar claim made by such invention. So there is hardly any value addition or different claims filed during the patenting process. Further in Kala Jeera, Amla, Kali Mirch, Chandrabhaga, see the indigenous use and see the use as claimed under patent. So there is hardly much difference. Terminology may vary, but there are similar applications. So there is no any novelty, and companies try to commercialize indigenous use under the guise of patent. Further, in Magista, Imli, Ashwagandha, see indigenous use and further use as claimed under patent. These are similar uses which are indigenous and claimed under the patent system. Further in Arjuna, Hara, Bahira, again the indigenous use and the patented claims are similar one. So the world best pharmacy according to Ayurveda, or as per traditional knowledge, I hope you must guess. So this is kitchen. So all such herbs we may find in our kitchen. So appropriation of bioresource and the associated traditional knowledge, specifically by patenting, was observed in all such previous slides. So the trend of patenting in the present subject seems very disturbing, because if they succeed to patent, then this is a legal monopoly and no one can commercialize such type of inventions based on traditional knowledge without the prior permission of patentee, the right holder. And this is quite wrong, because the stakeholder who having hardly any rights in such patent or any benefit in the commercialization by such patentee who monopolize and misappropriated others' bioresources and the associated traditional knowledge. And there are so many cases of wrongly granted patent, not only in India but worldwide, in this field. So there is hardly any prior informed consent with the stakeholder, and there is hardly any access and benefit sharing. And that's why we saying it a biopiracy or unethical business practices. So this is against the ethics. Regulation of patenting of such resources is needed urgently since long. So such patent applications and grant of patent are highlighted in media time and again. So what are the solutions? So we have a big problem to safeguard the interest of stakeholder for their bioresources and the traditional knowledge they are maintaining since long. They are passing such precious information generation to generation, and there are so many commercial entities trying to misappropriate their resources and the knowledge. So recently, last month, in May 13 to 24, there is a WIPO diplomatic conference on genetic resources and the associated traditional knowledge in Geneva. And there are around 1,200 delegates, including government ministers, observers, and other stakeholders across the world, join this conference. And the major aims are to enhance the efficacy, transparency, and quality of the patent system, and particularly to prevent patents from being granted erroneously for inventions that are not novel or not inventive with regard to genetic resources and traditional knowledge associated with genetic resources. So whether bio-inventions can be patented or not. So it depends. And what is invention and what is patent? Hopefully you all understood such questions in earlier presentations. Particularly, invention is defined in Section 2 of Patent Act 1970, a new product or process involving an inventive step and capable of industrial application. That means the invention may be either a product or may be a process. So invention may be a product or process or both. So in single application, we may claim a product or process or both the product and process in the same application. Country-wise, the norms may vary. Like in China, it considered multiplicity of inventions. So we have to divide the application, one for product, one for process. But in India, we can cover both in single application. And further, the involving an inventive step. So there must be non-obviousness in the invention. So invention must be new, invention must be non-obvious, and invention must have capability to apply in industry. Like there must be some usage, or it can be manufactured industrially to meet the demand of public. So based on the definition of invention itself, we may find the clue regarding the criteria of patent. So there is a novelty. Novelty of the product or process, that is novelty of the invention. Invention must be new. And further, there must be inventiveness. It should not be obvious. And further, there must be a utility. So these are three criteria for the patent. And what is patent? Patent is a legal rights. Patent is a type of one IPR. So it is an exclusive right. It gives exclusivity to the inventor or the applicant to exclude other, not to commercialize their patented invention without prior permission. So patent is an exclusive right granted by the government for an invention which is a product or a process that provides in general a new way of doing something or offer a new technical solution to a problem. So this is the inventiveness, doing something or offer a new technical solution to a problem. So this must be non-obvious. So how can we invent or patent? We need to carry out our research or project, identify some problem, try to solve such problem with a technical solution, And if we have such technical solution, we may proceed for patenting. Further, criteria 1, that is the novelty. In 2005 amendment, the term new invention is clarified, providing absolute novelty. So novelty is judged not nationally but internationally. And new invention means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of a patent application with complete specification. So before filing a complete specification, your invention must be new. Nowhere it published, that is the subject matter has not fallen in public domain or that it doesn't form part of the state of the art. And regarding the second criteria, that is inventive step, it is defined in the Patent Act. It means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both. Both सोने पे सुहागा. Either you have to justify involving a technical advancement as compared to existing knowledge, or there must be some economic significance in your invention and that make the invention not obvious to a person skilled in the art. So there is a word posita, person having ordinary skill in the art. Unfortunately, this person skilled in the art has not been defined in the act. So this is a virtual person, but this virtual person treated like a person skilled in the art. So the field of invention, this Hosita, the person skilled in the art, is well aware about this field of the invention, so he can understand the invention. And if such person understand this invention is obvious, then even the invention involve a technical advance and economic significance, but based on the person skill in the art, if it seems obvious, it cannot be considered inventive. So further in section 3, there is a list of inventions which are not considered for patent. So there is no any discussion, no any argument with the patent office regarding such inventions which is listed under section 3. So I am quoting two particular sections, section 3D and section 3P, which is relevant in the present topic, traditional knowledge. The first one is 3D, mere discovery of a new form of known substance which doesn't result in the enhancement of the known efficacy of that substance, or the mere discovery of any new property or new use for a known substance, or the mere use of a known process, machine or apparatus unless such known process results in a new product or imply at least one new reactant. Mostly this section is applied in field of chemistry and pharma, in biotechnology. And section 3P, that is generally used in the case of traditional knowledge related inventions. Read it. An invention which in effect is traditional knowledge or duplication of known properties of traditionally known components has been made non-patentable. So any ready-made formula of traditional system of medicine cannot be patented as per section 3P. So once you file the application, this is the form number 1, application for patent. So there is a top-up. Not top-up, this is a pop-up. If your invention is based on any research oblique information on a biological resource obtained from India, prior approval of National Biodiversity Authority is mandatory for a patent under Section 6 of the Biodiversity Act 2002. So no need to go to NBA website at this first stage of filing the patent application because NBA needs time to approve for such bio resources for patent purpose. So we can do it at later stage. Once our patent is considered, we can arrange this approval from NBA at the later stage. So patent office will hold the accepted application for patent till the time we may arrange the approval from NBA. And in Form 1, at the last page, there are some declaration. First and second declaration is default, and other declaration we need to tick. So see the second declaration. The invention as disclosed in the specification uses the biomaterial from India and the necessary permission from the competent authority shall be submitted by me before the grant of the patent to me or us. So we have to tick this declaration at the time of filing the application which are based on some bioresource or the associated traditional knowledge. Patentability of applications based on bioresource and the associated traditional knowledge. So they are objections mostly on novelty point or inventiveness point, and it is noted that most of the applications during examination found either not novel or seems obvious or non-inventive or both. So there is a FER, first examination report, or SER, subsequent examination report, where such objections along with the citations, whether patent citation or non-patent literature, we may find in the examination reports. So a study analyzed patent application filed in India during year 2004 to 21 and enlist the main grounds of refusal of the patent. In subsequent slides, we can see the major grounds of refusal of such kind of patents. So India has successfully initiated set up an institutional mechanism named TKDL. This is a traditional knowledge digital library which help in stabilizing prior art and protect the country TK from wrong patenting. So this is a really wonderful tool to regulate this misappropriation. So most of the time, it successfully revoke the granted patent or even successfully helping in withdrawing the applied patent application for patent. So such application during the examination process itself decline from patenting. So this database, Traditional Knowledge Digital Library, has around 34 million pages that include 2.90 million compositions of diverse medicine system of India. Actually, this database is a software and it helping in public awareness, research and development purpose, recognition of the concerned local society, protection of such resources and knowledge, and helping in prior documentation, stabilizing patentability, and easy to oppose economically and efficiently. The best feature of this TKDL is efficiency to oppose economically and efficiently. There is hardly any expense opposing such applications which are based on such resources of knowledge. So there is a classification system and it converts text in local language into multiple international languages. Using Unicode and metadata methodology, The software converts traditional terminology into modern terminology like turmeric, that is haldi, to curcuma longa, the scientific uh, name of turmeric. Similarly, neem to Azadirachta indica, basmati rice to Oriza sativa, jowar to fever, kumari to aloe vera, musorica to smallpox. So, using this conversion technology, it is easier to convert local languages into multiple international languages so that internationally patent office can examine the filed application with the help of TKDL so that a proper examination of such application conducted. It includes search interface which provide full text search and retrieval of traditional knowledge information on IPC, that is International Patent Classification, and keywords in multiple languages. The search feature includes single or multiple word search, Boolean expression search, field search, phrase search, etc. So searches are also available on IPC and TKRC codes. So revocation of wrong patent based on Indian traditional medicine. So there are some common examples which I hope all participants must aware, like use of turmeric for wound healing properties. This is a Indian traditional knowledge. Similarly, antifungal properties of neem, diabetes medicine made from extract of jamun. So these are very common traditional knowledge. Already some applications for patent based on such knowledge filed in major countries like US, UK. So turmeric case is the first example which is successfully challenged by CSIR, and similarly EPIDA successfully challenged the Basmati case, and such cases in challenging the expense is in crores, multi crores. So the idea of such a TKDL comes to the CSIR that this is the endless litigation, endless opposition, endless restrictions. So why not we devise some database where all such national traditional information covered, and if such database is recognized internationally like from WIPO, it will be very easier to revoke all such wrong patents or wrong applications for patent. So USPTO revoked the patent, stating that the claim made in the patent were obvious and anticipated, and adding that the use of turmeric was an old art of healing wound, and perceiving need of digitization of TK of India to protect it from patent biopiracy, especially in the field of medicine, and it consequently led initiative called the Traditional Knowledge Digital Library. So there are some news regarding the success story of TKDA. So there are various sources of news like BBC, Times of India, and see, they mentions the particular plant and the traditional use of such plant along with the patent applicant who applied such traditional uses for the patent and the particular patent application number in US, in Europe, etc. And the particular patent office like US Patent Trademark Office, European Patent Office, and who oppose such wrong patenting or applications for such patent like Green Party, CSIR, TKDL itself, some other NGOs, and finally the status of such applications are either they revoked, either they withdrawn. Similarly, there are more cases covered by India Today, Hindustan, Times of India, and see the traditional usage of plants like bhang, aloe vera, ginger, kutki, cow milk, jamun, long. Chandan. And these are the major MNCs applicant like GW Pharma, Australian company, Nicholas John, Dawkins, Nestle, Osthachen, and they applied in Europe, Australia, Great Britain, Chennai in India. So there are different patent office like Indian Patent Office, European Patent Office, British Patent Office, Australian Patent Office. And further the opposite are either TKDL or Department of Ayush, CSIR, various Indian government officials, EPIDA, etc. And finally the status is withdrawn, terminated before grant, revoked. Further, there are more cases covered by various news channels and see the different plants and their traditional usage. And all such cases successfully challenged by Indian institutions, particularly CSIR and other NGOs, and finally they succeed to reject such applications. So India TKDL impact on patent application in the field of bioresources and the associated traditional knowledge. See the impact. Already such previous slides prove the impact, positive impact of TKDL without incurring any cost in maintaining such evidence, arranging such evidence. So just referring the TKDL citations, work done. So it expedite refusal and revocation of such incorrect granted patent letter, which require huge efforts, time, funds earlier to TKDL. So there is a total saving of efforts, time, and fund with the help of TKDL. Restricting grant of patent to invention which in effect is TK. So those invention which is in effect is traditional knowledge, it helping in restricting such grant of patent, prohibiting patenting over the invention which are either known properties of natural resources or the associated knowledge. As expected, TKDL worked very efficiently, revoking wrongly granted patent internationally, helping in refusal and revocation of such patent application and the wrongly granted patent. So there are multiple benefits of such TKDL. And after TKDL, so far, thousands of patent applications filed by commercial entities in different countries have been set aside or withdrawn or amended upon citation of TKDL and so efficiently without wasting much time and neither incurring any additional substantial cost. So effectiveness of the TKDL of India has been studied showing decline in filing of patent application in this subject. So after TKDL or see the impact of such TKDL, there is a decline of such applications not only in India but worldwide. So it acts as a bridge between new science and traditional knowledge and can be used for catalyzing higher research and innovations. This database is earlier not in public, only the patent office have accessibility of this database, but recently it made public accessible with some paid subscription. So such TK database is recommended to be used as source of prior art citable for novelty or inventiveness to prevent grant of incorrect patent. Realizing importance of TKDL, WIPO suggested member countries, there are around more than 150 member countries of WIPO. So it is suggested to all such member countries to adopt model of Indian TKDL as their national model for protection of their concerned associated knowledge of their bioresources. So support at international forum is required at priority to get country-wise such database of TK to be included as PCT minimum documentation. What is PCT minimum documentation? That is, if international application file in this field, so there is some minimum PCT documentation which need to be verified during examination of such filed application to prevent biopiracy and such misappropriation. Awareness program are required for adequate awareness on this subject among the stakeholders. So earlier, in various patent office, see the number of cases during 2016 to 2022, 2020. Around 230 cases filed in such major patent offices worldwide. So this is the TKDL outcomes. So all such cases are rejected or withdrawn based on TKDL citation. So there are some observation and recommendation based on TKDL. It is used as a source of prior art citable for novelty and inventiveness to prevent grant of incorrect patents. And so this database is an excellent instrument intended for offering protective defense. So it is also clear now that as TK is ubiquitous in nature on global level, so defensive measures taken on national level are not enough to protect or safeguard it, and this may pilot it to its inappropriate use on international platform. Therefore, global local tool on international level are essential and a precondition to give steady and tough defense to every traditional knowledge. So database for such knowledge should be prepared by every nation. It may be offered by all such nations, and ultimately the whole humanity may get advantages by different nations' traditional knowledge, because there is a utility of such knowledge. And if such knowledge is codified, documented, maintained in database, and if such database is merged, there is a global database on this subject, so that the humanity may get multiple advantages worldwide. So support at international forum is required for such a country-wise database, and further to be included under PCT minimum documentation. So all applications for patent relating to TK are identified, screened and classified as traditional knowledge by RECS section. So in patent office, there is a RECS section, and the task of this section is to identify the applications which are in the nature of traditional knowledge, and accordingly they are classified. In spite of the strict screening at patent office, it is noted that some applications wrongly classify in other field, like traditional knowledge chemical rather than traditional knowledge biological or biotechnology. So as per the guideline, the examiner need to carry out a careful prior art search in TKDL and other database to examine the application. And it is noted that around 50% of such applications were objected under section 3P. Ideally, if such application is screened and tagged traditional knowledge biotechnology, then almost all such applications must have objections under section 3P. And further, the copy of the citation English translated which are made from TKDL should be sent along with the examination report, which is generally not arranged by the patent office. So in practice, it was noted that hardly such extract of TKDL arranged with the examination report. However, it may be arranged on the applicant request. So once the applicant requests to patent office, they will arrange such citations. So there are various laws relating to traditional knowledge and biodiversity, biological material. According to Patent Act, invention means a new product or process involving an inventive step and capable of industrial application, and thus traditional knowledge cannot be considered invention. And Section 6 of the Biodiversity Act 2003 mentions no person shall apply for any IPR, including patent, by whatever name called in or outside India for any invention based on any research or information on a bioresource obtained from India without obtaining the previous approval of NBA, National Biodiversity Authority, before making such application. We can apply and we can arrange this NBA approval later after acceptance and before the grant, provided that if a person apply for a patent, permission of the NBA may be obtained after acceptance of the patent but before the sealing of the patent by patent authority. Provided further that the NBA shall dispose of the application for permission made to it within a period of 90 days from the date of receipt thereof. So earlier there is no any such timeline, so there is unnecessary delay in disposal of such patent application. Further, in Patent Act 1970 and Rule 2003, it supplements the law on biodiversity, particularly the Biodiversity Act 2002, as needed a declaration from the patent applicant under the patent form number 1, which required to mention that the invention as disclosed in the specification uses biomaterial from India and the necessary permission from the competent authority shall be submitted. And further, the Biodiversity Act 2002 has some biting teeth as indicated punishment for non-compliance. So, non-compliance of such Biodiversity Act 2002 may attract around 3 lakh to 5 lakh or imprisonment 3 year to 5 year or both. So there is a guideline for processing of patent application relating to traditional knowledge and biomaterial. And under guiding principle 1, if the subject matter as claimed relates to extract, alkaloids, and or isolation of active ingredients of plant which are naturally or inherently present in plant, such claim cannot be considered novel or inventive when use of such plant is pre-known as part of teaching of traditional knowledge. So when the subject matter of claim relates to extract of plant material containing undefined active ingredients, such claim cannot be said to be novel. Although there are some value addition, the inventor or researcher had some efforts to find the active ingredients, but just due to the plant is known, no matter which part of the plant is exercised during the research to extract that active ingredients, generally patent office don't consider such efforts for the patent purpose. If the plant is known, no matter which part of that plant is useful for the applied claim, such claim cannot be said to be novel as per this guideline. And if the use of such plant or plant material is pre-known as the part of teaching of TK, however, if the claim relates to alkaloids and or active principle obtained from the plant material and the structure of the said alkaloids or active principle are characterized, which don't form the part of prior art. Again, another issue, not the novelty, but the inventiveness. Such claim cannot be said to involve an inventive step because it is argued that no matter this is novel, but this is obvious. So invention is novel but obvious, and that's why unable to fulfill the second criteria of patentability, that is inventiveness. And since the use of said plant material and their therapeutic effects are known from the teaching of TK, thus the prior art motivates the person skilled in the art to isolate the individual ingredients such as the particular alkaloids or flavonoids or phytosteroids. And that's why such exercise, such invention is considered obvious one, not the inventive one. See the illustration. So patent application claim relates to an extract of the Videnia plant for the management of stress. So this is the claim. And prior art disclose use of this plant root and not Videnia plant extract for the treatment of stress related disorder in Ayurveda and Unani system of medicine. See the analysis. The claim of allied invention relates to an extract of Videnia plant. Based on the prior art, it can be objected that extract of Videnia somnifera would be useful in treatment of chronic stress disorders such as insomnia, gastric ulcer, hyperacidity, restlessness, and depression. and therefore the subject matter of claim is not considered novel. See, this plant root and not other parts is disclosed in the prior art, and the claim made relates to an extract of Videnia plant which may not be the root of this plant, maybe some other part. But again, the end result seems obvious in view of known properties of this plant, no matter which part of this plant. And that's why not considered novel over the teaching of prior art. Further, in next illustration, see, this is the case of invention proved novel, but again the problem of obviousness. So, unable to fulfill the second criteria, that is inventiveness. In this case, patent application claim relates to an alkaloids chemicide derived from Roman or German chamomile for the treatment of cancer, diabetes mellitus, arthritis, acne vulgaris, eczema, and for wound healing. And prior art disclosed use of German chamomile from which chemicide is derived in wound healing and for the treatment of cancer, diabetes mellitus, arthritis, acne vulgaris, eczema in Ayurveda and Unani system of medicine. The prior doesn't disclose this extract chemicide, and that's why successfully established the novelty. But see the analysis. Based on the prior art, it can be objected that German or Roman chamomile has already been used alone or in combination with other ingredients for aforementioned indication, and therefore the prior art motivates the person skilled in the art to isolate and identify the active ingredients such as chemicide, which has the same therapeutic effect. Since there is the same therapeutic effect, hence the isolation and characterization of the same cannot be considered to involve an inventive step. And that's why there is a decline of such patent applications in this field. Again, accessing novelty with the guiding principle 1. This principle 1 states that the invention which rely on alkaloids or extract and or isolation of ingredients of bioresource which are inherently present there naturally in such natural resource like plant or particularly where it is a part of prior art and especially take care should not be understood novel or new. For an example, quinine to treat malarial fever is a traditional knowledge of Amazonian as the knowledge that the same is accessible from bark of the tree, cinchona. Restrict patents over the cinchona for such use. So in some other jurisdiction, identification of the specific constituents which are the active constituents and the further the process to isolate such active constituents may be considered new or inventive or both. So country to country, see the norms may vary. Some country considered it obvious and some country considered it non-obvious. Again, guiding principle 2 to 6, accessing inventive step, and such 5 principles reveal an opinion of not inventive in relation to what exists prior art to the subject invention. In some countries, the motivation to combine 2 or more arts is not indicative that an individual, that is Posita, person having a skill in the art, will have a reasonable expectation of achieving the anticipated output. So these are some main section of Patent Acts which is cited in first examination report, FER. Section 10 for second D. The source and geographical origin of such biomaterial used to prepare the invention are not indicated in the specification. So there is a compulsory requirement to highlight the source and geographical origin no matter if we miss this information during the filing, once this objected during the examination report, we can arrange this information. And further, as per the definition of invention, sometimes the applied invention is not considered invention as per this definition, and so the objection raised like the invention doesn't reflect any technical advancement in the subject and the claimed invention is not patentable for lacking an inventive step. So what is inventive step? Inventive step means a feature of an invention that involves technical advance as compared to existing knowledge or having economic significance or both. So if the invention don't fulfill either the requirement of technical advancement or economic significance, it is not considered inventive. So further, in section 3E of the Patent Act 1970, a substance obtained by a mere admixture resulting only in the aggregation of the properties 2 plus 2, that is 4, then this 4 is the aggregation of this property 2 plus 2. But if the result is either 5 or 6 or something else, so this is not the mere aggregation of the properties. It may consider synergistic, and that's why in such applications, Patent Office asks the data regarding the synergy of such invention, how the admixture proved synergistic rather than having only made the aggregation of the properties. So we need to arrange comparative data of the claimed composition. Further objections like 3I, any process for medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human being, or any process for a similar treatment of animal to render them free of disease or to increase their economic value or of their products. So if inventions is understood like a process of treatment either of human being or animal or plant to render them either free of disease or increase their economic value, there is objection of 3I. And under 3P, which is already discussed, that if in effect invention is considered per se traditional knowledge or aggregation or duplication of known properties of traditionally known component, the objection raised under section 3P. A newly added process claim is not allowed. So these are some common objections, and during the patent prosecution, opportunity for correction, explanation, and amendments had been given as per the provision of the Act. So applicant was provided with the ample opportunity for explaining the subject matter of the applied invention in view of the technical objection raised by the patent office. By issuing first examination report or subsequent examination report or any further office action, the applicant provided with the gist of objection for making correction or amendment within a period that is mentioned in this examination report or office action. Eventually, whenever it was revealed that the subject matter of the invention was not patentable as per the Act, application refused only after an opportunity of being heard to the applicant under the law. So the applicant is given lastly an opportunity to appear in personal hearing with the patent controller. This hearing, as per the choice of the applicant, either be offline or online. Mostly nowadays, people prefer online hearing. So after filing of amendment in respect of claim of the complete specification, the application was further examined and hearing under section 14 of the Act was offered, giving the applicant an opportunity to contradict the final outstanding objection. In many such applications for patent, application didn't provide any submission with respect to raised objections because most of the time such applicant is understood that this is in contradiction of the law and this is considered traditional knowledge or there is no any novelty or no any inventiveness. So there is no any point to argue or how to establish the patentability of such filed application. So in many times there is no any submission made by the applicant or his agent. So it was noted that in many cases applicant either failed to comply with the requirement or not interested in pursuing the case after the requirement of outstanding objections as raised in hearing letters. So they hardly appear in such hearings. So these are some of the cases of refused patent application. These are the application number. Earlier, the format of this application number are in India, like a number oblique Dell or Dell NP or MUM Mumbai, CHE for Chennai, DL for Delhi, KOL for Calcutta, and after these 4 digit 2004 or 2006, these are the year. See the biological entities covered under that applications and the utility which is claimed by such patent application. So they are a long list. See, all such are refused patent applications, and in most of such applications, the applicant is not interested to attend the hearing, and after attending the hearing, the fate of all such applications was accepted. And see now some granted patents in India in the field of biological resource and traditional knowledge. So these are the patent number. So please note application number and patent number is different. So don't use application number as a patent number. Anyone can file any patent application. So this is the easiest task to file a patent application. Main thing is grant of patent and the commercialization of patented invention. In publication of patent is default. If you file any application after expiry of 18 months, it will default published by patent office. Only in case you are interested for early publication, you have to request along with the prescribed fee on prescribed form, that is form number 9 for early publication. So within 1 month of such request, your application will be published. So there is no any benefits of such early publication or filing patent which don't fulfill the criteria of patentability. Ultimately, such applications don't grant it. So see the wrongly granted patents. There are many wrongly granted patents. Like other IPR, patent is territorial in nature. So we need to file applications nationally, and every country examine the applications as per their own nation norm. So invention based on traditional knowledge are internationally tried for patent. So there is an international application, but there is no any international patent. Ultimately, we have to enter in national phase, country-wise. Some of such patent applications are wrongly granted in spite of not qualifying the criteria of patentability. It is noted that some applications wrongly granted patents in spite of not having novelty or inventiveness or both. Why such happened? Actually, once examiner examines such application, there is a limitation of resources like a database, whether a patent literature or non-patent literature. If such information is not covered under their resources, their database, as per the available resources, they may examine the application and find nowhere it is mentioned in the prior art. So as per the examination, it seems novel, but this is wrong examination because such information is already available anywhere in the world, no matter whether such information is covered under their database or not. And that's why no patent is a absolute patent. A person interested may oppose such patent applications at both level, pre-grant and post-grant, and that's why there are two publications of every patent application: pre-grant publication and post-grant publication. In pre-grant publication, any person can oppose such application based on grounds mentioned in section 25, and for post-grant publication, only the person interested may file opposition, and so during 1 year from the date of grant. So many times it is observed that the information in public domain in one country may not be available in other country, either due to language barrier or any other reason. On few instances, it was observed that information in public domain in a country may not be available in other countries either due to lack of codification or translation or awareness, or such application may be considered novel. That is wrong examination. National Patent Office worldwide examine the patent application with their limited database, and that's why this problem. There is a need of more initiative to prohibit misappropriation of traditional knowledge and granting bio-patent on TK-related inventions. To enhance benefit sharing with the stakeholder, particularly the indigenous society maintaining such traditional knowledge since generations. So news in media on such patent application has highlighted such misappropriation of bioresources and the associated knowledge, and a person interested, hardly any person interested for such pre-grant opposition may oppose, and only the person interested, if unable to oppose it timely, they may oppose it after grant. So such opposition are very expensive and need time and efforts earlier. But see the example of EPIDA that covered 7 crore rupees towards legal fee only to get revoked mere few claims of patent earlier in Basmati rice case. So some countries initiated framing database of indigenous traditional knowledge to make it accessible to patent office so that the patentability criteria, particularly the novelty, may be accessed. India is the first country which has developed such a long-awaited database, that is TKDM. In India, such applications are opposed by entities like government organizations including CSIR, ICMR, EPIDA, etc., and some NGOs like Navdhanya. Many times, such wrong patents successfully revoked or the application cancelled by the concerned patent office worldwide based on such citations. Don't know why this slide is taking so much time to open, so I am skipping this slide. So illustrative example of patentability issue. So based on section 3J and section 10.4, there are some objections. So in view of the time involvement of to explain such examples, I prefer to skip. Some observation further. Surprisingly, in India, many applications in the field have been granted. So most of the applications in the field of traditional knowledge biotechnology are abundant because during the examination process, they are a relevant citation, the prior art, and that's why applicant abandon such filed application. And abundant are very high in number as compared to granted. So no matter how many applications filed in this field, most of the applications are abandoned by applicant themselves after the issuance of examination report, and so very few patent applications are granted in this field in India. So time, funds, efforts are involved in patenting process, and therefore it is demotivating for the applicant and the innovator to move forward in the subject. So urgent need of certain document to easy evaluation of patentability in this subject to help to facilitate the process of patenting in the subject. See, I'm a neutral person in this field because see we may have our own interpretation of such kind of things. Whether we promote patenting in this field or not, generally our stand is not to patent such kind of things or subject. If we don't promote patenting in this field, there are other players which use chemicals alternate to such herbal products, and further there is no any promotion of such bioresource and traditional knowledge. So ultimately there is hardly any commercialization of such resources and the knowledge. And if there is no any commercialization of such knowledge and resources, there is no talk on benefit sharing to the stakeholder. So in order to have a better access and benefit sharing with the stakeholder, patent may be promoted in this field. So if there is a value addition based on related knowledge, such kind of inventions may be considered for patent so that some benefits may be shared to the concerned society. So, Patent Office of India, reaffirming its commitment to protect traditional knowledge and biomaterial, is released in guideline in December 2012 for the processing of such patent applications. After pursuing through the submission during patent hearing and the documents as submitted on the behalf of applicant, some of the conclusions are most of the applicants are either abandoned or refused for grant of patent as lack novelty or inventiveness or both. And most of the applications attract section 3, particularly subsection E, P, E, that is the lack of synergistic effect of the mere admixture, and P for which relates to traditional knowledge. And there are some challenge including rebuttal of objections of patent examiner in case of bioinvention based on traditional knowledge, checking the due disclosure of the origin or source of such bioresources. Further, prior informed consent from the stakeholder. Restricting such biopatent may hamper the research and development over such resources and ultimately prove a hurdle in the way of prosperity, not only for the stakeholder but the whole mankind. And so we can say this IPO guideline 2012 seems discouragement as hits indigenous knowledge as well as their stakeholder, because in absence of continuous research and development which can be sustained only through promising due rewards to it, field of commercial drug will get automatically available only to chemical drug manufacturer in absence of competition from such traditional drugs. So FER of such application indicates objection of section 3P, and hardly 50% of such applications mentions this section 3P. Claim of such application either lack novelty or inventiveness. Trend of filing application is nowadays low due to patentability issues, and the indigenous community don't have adequate awareness or fund to safeguard their TK, and effective policy in the subject to is needed to promote its sustainable utilization and sufficient IP protection. So current provision of the patent law of India are obstructive in nature for getting patent on this subject. Some argued that why a stakeholder of TK should be deprived of commercial benefits of TK. So if we have to invite researchers from basic science to ensure quality, safety and efficacy of such TK-based medicine, there is an urgent need to amend laws of patent with pragmatic promotional policy. This will encourage more patent on numerous pharmaceutical, nutraceutical and cosmetical products based on traditional knowledge. So as per stakeholder comments, identification of the specific constituents which are the active constituents and further the process to isolate such active constituents may be considered new or inventive. So far India Patent Office don't consider such identification of a specific constituents or isolation of such active constituents inventive or novel. So further, the comment received that any firm methodology judging the patentability in this field discourage research and development and foreign direct investment in such countries. Further, additional disclosure requirement impose a burden on the applicants, as ascertaining the origin of such resources is difficult sometimes, and some necessity are not intended as the objective of CBD. As per conventional biodiversity, there is no such requirement to mention origin of such resources for the patenting purpose. Substantial time, quite often many years, and energy is lost in an endeavor to secure clearance from the NBA earlier. Nowadays, there is a timeline within 90 days, they have to arrange the approval. So determining an invention whether based on TK or not, it is not very clear. It's hardly indicated in the file record. See, anyone can access patent portal using the application number, and all such documents which is communicated by the applicant to patent office or patent office to the applicant is uploaded online on that portal, and so this file record is accessible to any person. It seems a need for a robust procedure to access TK in published application. So many times there is no any highlights that this application relates to TK. And in TK based application, there is no such objections sometimes under section 3P. So patent application in the subject should disqualify if not comply with such international obligations, particularly prior informed consent, access and benefit sharing, etc. So criteria of patentability in this subject may be moderated and to balance the interest of concerned parties, and such norms need to be complied strictly. Publication of such news need to be promoted to sensitize the stakeholder. Continuous addition of unadded traditional knowledge in the TKDL is needed. So knowledge should not be restricted, and TK would be treated like gift to the present and future generation from the earlier generation. However, the holder of it should be recognized and incentivized for its commercialization. So there is a case against Divya Pharmacy of Ramdev under the State Biodiversity Board claimed in crores for the benefit sharing, and this is the main issue under the litigation which is appealed by the Ramdev company Divya Pharmacy in Uttarakhand High Court, and finally the High Court decided in favor of State Biodiversity Board, which is not very clear in the Biodiversity Act. And see, Uttarakhand Biodiversity Board sent a notice to Divya Pharmacy in early 2016 stating that the company was in violation of Biodiversity Act for using bioresource from the state for its Ayurveda product without duly intimating the board, and that it was liable to pay ABS fee. So, challenging the board notice, the company filed a writ petition to High Court. It showed that court interpretation of the provision of Biodiversity Act, particularly Section 7, which require Indian entity to give prior intimation to the State Biodiversity Board before obtaining bioresource for commercial utilization. So, as per the law, the company intimate the State Biodiversity Board. So, the four respondents in this case were Union of India, Ministry of Environment, Forest and Climate Change, Uttarakhand Biodiversity Board and National Biodiversity Authority, and the state of Uttarakhand. The petition challenged the power of State Biodiversity Board to regulate access and determine benefit sharing upon access by Indian entities. Finally, 2 years later, the judgment decided in favor of Uttarakhand Biodiversity Board. See some development in this field, like in 1994, India became a party of CBD, Convention of Biodiversity Board, and 2002 Biodiversity Act passed by Parliament, and 2003 National Biodiversity Authority set up in Chennai, and 2004 next year Biodiversity Rule is issued, and in year 2014, after 10 years, India became the party to CBD Nagoya Protocol on Access and Benefit Sharing, and in same year there is guideline on access to bioresources and associated knowledge and benefit sharing regulation notified by National Biodiversity Authority. So there is a need of protection of traditional knowledge, so no one can misappropriate without any prior informed consent and benefit sharing. So there are various laws relates to this subject, and this is a long list. And further, see there are some international initiatives and the Indian initiative accordingly. So far, there is no any initiative like TKDL worldwide. Recently, in some countries like Australia and some countries which are rich in biodiversity, like Africa, they are working on digital library on traditional knowledge. So individual country is free to make policy to protect traditional knowledge nationally. Due to national limitation, there is a need for an international framework. So such national efforts is not sufficient in this field. International protection would also open up access to mine of traditional knowledge held by indigenous communities. And international regime for recognition and protection of TK are Convention on Biodiversity and Nagoya Protocol, WIPO. There is a further some Indian laws and the concerned authorities in this field. like Patent Act, TKDL, GI Act, Protection of Plant Right and Farmers' Right Act, and these are under different ministries. And see some government norms on it. And further, there are option of fair and equitable benefit sharing. There are monetary benefits and there are non-monetary benefits. And percentage is depends on kind of applicant and the condition whether applicant has entered or not entered for benefit sharing agreement prior to access. And as per the annual gross ex-factory sale of product, benefit sharing component may be decided. And finally, there are some recommendations like prior informed consent, access and benefit sharing, and some of the most useful arrangement to balance the interest of a stakeholder. And Biodiversity Act is one of the most useful act on this subject. Interaction with member of authority like National Biodiversity Authority can be done while raising concern and critical issue with them. And some of them are mentioned like to teach and team up with government official and ministers like MP, MLAs by means of sequence of conversation in conducted meetings to create memos and declaration not only district-wise, state-wise, but also nationwide. To work for diffusing consciousness concerning such topics amid communities, NGOs, and public officials. So awareness on this subject is needed urgently, and unfair business practices in this field must be regulated so that business without ethics should be regulated. So this time for the issues which may be raised in your mind, please feel free to ask questions. You may ask issues either by chat or different fields of IPR, not only in traditional knowledge but on patents.
Okay, participant, any question, query can put in the chat box. So there are some question. Is proposed TK bill 2022 effective? That is a question. Another question, protection of TK will not fit in IP and how protection can be given for knowledge recorded in PBR. There are some questions.
Protection of TK will not fit in IP and how protection can be gained for knowledge recorded in PBR. Plant breeders' right. So see, traditional knowledge itself is not considered IP and it cannot be registered like IPR, and that's why we promote TKDL, Traditional Knowledge Digital Library, so that at least no one can misappropriate such traditional knowledge for undue commercialization. And that's why the concept of people biodiversity register. So state-wise, there is a biodiversity registered, and people can register the biodiversity information in such register so that such information can be regulated nationally. And many times the commercial entities are not aware about the source of such biodiversity, and that's why there is a difficulty in contact and arrangement with the stakeholder, and that's why there's a role of NBA, National Biodiversity Authority. We need prior approval from the NBA, and the role of NBA here is to find the stakeholder and to promote the interest of the stakeholder. They use this fund, access and benefit sharing fund, to promote the interest of a stakeholder, and a stakeholder may be identified with the people biodiversity register. So many times applicant argued that we purchase these bioresources in the local market, so we are not aware who are the stakeholders. This society maintain this knowledge since long, and that's why NBA getting the funds from such applicant using this fund for the welfare of that stakeholder.
Thank you, sir, for sharing your invaluable insights on traditional knowledge and IPR. Your expertise has truly enriched our understanding of the subject. I would also like to extend my gratitude to all participants for active participation. For now, to formally conclude today's session, I would like to invite Dr. Uvi Shah to deliver a vote of thanks. Over to you, ma'am.
Good evening. Thank you, Judy N. Am I audible?
Yes, ma'am.
I'm Dr. Urvi Shah, Assistant Professor at Government Law College, Ahmedabad. On behalf of all the participants of this 3-week online faculty development program in IPR, I take this opportunity to thank our esteemed speaker of today, Dr. Pankaj Kumar, sir, who is also a part of the organizing team, for a very, very enriching and insightful session. It was a pleasure, sir, listening to you. Thank you for sparing your valuable time from your busy schedule and explaining us the details and legal aspects with regard to traditional knowledge. Your rich experience in this area has truly benefited all the participants present here. Lastly, thank you all the participants for enthusiastically participating in this FDP and making it a grand success. Thank you, one and all. With this, we conclude today's session. Thank you.
Thank you.
Thank you,
Pankaj,
sir. Thank you, Judy.
Thank you.
Thank you, Pankaj, sir.
Thank you very much.